the plaintiff in that case, who's respondent here, has filed a contest of that. So is that correct? Am I kind of on track there?
Yeah, that's correct, Your Honor. This is Roy Brandes for Mr. and Mrs. Whitman.
All right. And so you all are contesting their ability, well, whether they have the ability to post the bond. Is that correct?
That's correct. We filed the contest of the affidavit, yes.
You're cutting out, so I couldn't hear any of them. Sorry.
That's absolutely correct. We filed a contest to the inability to pay the appeal bond.
So one thing that I noticed in the filings is that I think it was the defendant claimed that they had already moved out prior to this eviction order being entered. Is that correct?
Uh, I, I believe that's correct. She has moved out. Yes.
So it may be that the appeal is moot, other than if she's arguing that she moved out, so there shouldn't have been a judgment against her, that would be something that would be appealable. But do you all have some information with respect to her ability or inability to post the bond?
Well, we have information. We have information from her that she had bank accounts, that a bank account that she was employed during the time of her tenancy with us. I have those are dated May and April of this year. Those are the documents we have. I don't have anything current.
But
We
do you
assume
have anything that would indicate what the balance of the bank accounts are, or what she gets paid, or what all of her expenses are?
I don't really have anything on expenses, but I have one receipt from a Bank of America account where it indicates, and I filed this with the court, by the way, $13,480.17. That was dated April 20, 2026. Then we also have a receipt for a check deposit, May 13, 2026, in the amount of $17,103 and 46 cents. Those are the two documents we have relative to a receipt of funds by her and in a bank account that we understand is in her name.
Although the only problem is that we don't know that she still has those funds or what those funds were used for.
That's correct, Your Honor. Those are the dates. That's the information we had. We had representations. We have emails and texts and things from her where she's saying she's got these funds. She's going to pay us that type of thing. She confirms that she was either employed or had her own business and was actively involved in that. And obviously she references clients that she had and money that's coming in. But again, we don't have anything, as the court is saying, that she has money today, but we do have that information, which seems to indicate that she's got the ability to pay, and that's why we filed the contest.
Well, and certainly it makes for a strong argument that she has money, but what we don't know is that she still has that. If it was even her money, she's holding it for someone else. And since you're the one contesting her ability, you have the burden to show that she in fact does have those resources.
Is that, and I know I'm an eminent domain lawyer, okay?
Uh-huh.
But I read the rule, and I thought it said that the tenant bared the burden of proving that she could pay. Am I reading that
So
wrong?
she files a sworn affidavit on the or affidavit of inability to pay. And on that
Yes.
sworn statement, right, she's under oath that she says that she doesn't have the resources. So you would then come in to show yes, she does have the resources. And then we kind of go back and forth from there. So her statement is that she doesn't. Now, I looked at the application that she filed.
Yes.
In my opinion, it's lacking, mainly because it doesn't show anything other than she doesn't have any income. So it doesn't say
Right.
anything other than she doesn't have any income.
Because I think the affidavit, if I'm not, and again, you've probably done hundreds of these and I have not, but I read the rule to say that the affidavit is supposed to contain information regarding the nature and amount of the tenant's employment income, the nature and amount of any governmental benefits she has, all other income she has. There's like 7, 8, or 9 things she's supposed to put in the affidavit.
All of those things are correct that you're stating. And she indicated that she's not receiving any benefits from the government, that she doesn't have any income. She's indicating, let's see if I can go back and find it again. So in essence, she's done the bare minimum, right?
Yes, sir.
I'm looking at it now. So it shows that she doesn't have any dependents. So that's one of the requirements. She is not being represented by legal aid. She is not receiving any public benefits. It shows that she has 0 take-home pay or 0 monthly income. Let's see here. She says, according to this, she has a negative checking account. She does own a vehicle, a 2012 Cadillac CTS Coupe, that the value is about $2,000. She specifically marked that she has no expenses, no monthly expenses. Again, that only means that maybe someone else is paying them for her. I don't know,
Yeah.
but that doesn't mean that she has resources. She did file a statement that she didn't on her notice to appeal. Let's see. I'm not sure because there's no specific information other than she doesn't have any income. Of course, she's not here. And what I don't know is that the money that you've indicated, those deposits, if in fact that's her money, if she still has it, it seems to me, and again, I wasn't the one that heard this case, I don't think. But had she shown up, because this was a default judgment, she failed
Yeah,
to,
she did not show up, right?
yeah, so it would have done her some good to show up because if she had already tendered the property and had already relinquished possession of the property, then the case would have ended right there. And there would have been no need to appeal. So it could be that's what she's appealing, but her failure to appear
Well, there was it was not just an eviction, correct? Or we also got a judgment for several months back, rent that's owed. Yeah.
right. But even so, um, you could have gotten just the judgment since you already had possession, right?
Yeah. Yeah.
Yeah, and so what was being sought at the time was possession and the judgment. So it would have been a completely different argument had she shown up at the time. Regardless, the case on appeal is de novo. So, she'll have her opportunity to make those arguments as well as you being able to make your arguments under the circumstances, but
So, Judge, if I could, can I ask a question? So, if
sure.
she's not showing up, she has a history of this. We understand multiple eviction situations that we looked up online, and also found a significant judgment, a criminal judgment against her for a significant amount of money.
And it was my
I mean,
signature, by the way, on the judgment. So I'm looking
okay.
at it here now, yeah.
So, does the fact that she didn't show up today have any bearing on, the outcome of at least today's hearing? Can the contest be granted? And then what would she have to do for if you were inclined to grant the contest to her affidavit?
If are inclined to sign it in your favor, then she would have to then post the bond. She'd have 1 day to post the actual bond.
In the amount of
One day,
the
right?
5,700 that's in the judgment, is that
Yeah,
what?
whatever the bond that was put on there, so I think it was 5,700.
And then if she
Yeah.
didn't file the bond, then what happens? Is it
Then the appeal's
dismissed?
over.
Okay,
And she will have already passed for the time on the writ of possession, that you'd be able to file that right away.
okay. Well, I don't know. She hasn't shown up. I don't know whether that's significant or not in a situation like this, but she didn't show up to the hearing on the eviction. Didn't show up today. We presented some evidence to show she's had money available to her. Granted, we don't have evidence that she has it today, but we have evidence in the form of the documents we submitted that she was employed, which I guess is contrary to what her sworn affidavit is. She references several times in the texts and emails that she's working and she's so busy she can't ever call my clients back because she's busy with clients and the like and stuff like that. So I don't know. There's at least some evidence to show that she had an ability to pay this cost bond or in the cost. That's what we would argue. And for those
I'm
reasons, we,
looking
you know,
for what you filed in terms of, those bank deposits.
yes.
I don't see it.
Uh, we filed it on Friday.
What day was Friday? Today is the 27th, so the 24th. So maybe
Yes,
it
sir.
was marked on the 27th. Let's see.
And in fact, this morning, my legal assistant emailed it again saying that it didn't show, it wasn't showing up on your docket or whatever.
It's not showing up. Do you see anything in the email? We're checking right now to see if there's anything in
Okay.
the emails.
I mean, I think I have the ability to screen share or show you those if you'd like to see them.
Yeah, go ahead and do that.
Is that on the screen, Judge?
I see yes, the three icons on there.
Oh, but it's not showing the individual one? Is that right?
It's not open.
Okay.
And Diana, did you find anything in there? Oh, you're putting it in? Okay. She did find it, so she's putting it in now.
Okay.
Do I need to like reboot it? No, okay, there we go. All right, so what page would I find it on?
I think there
I'm
was,
going through all the text messages.
yeah, I think it's Exhibit C.
All right, I see the 13,480.17 is on the way. It was in April.
Correct.
And then
Yes.
America deposit for 17,000.
Right. Those are the two that I was referencing before.
And so how do I know that this is her account?
Well, the only way we would know is because maybe Ms. Whitman's on the call as well. I know there's a reference, I believe. The reason we have these is because Ms. Knight texted them to us, I believe. And so I believe there's a reference in the text to
Okay.
that. So that's the only reason we have these.
And so Ms. Whitman, if you can just tell me real quick, how did you come about receiving these two documents?
When she would respond to us, she basically would let us know, okay, it's coming. Stripe is going to release these funds to my account. Here's the proof. It's coming. It's coming. It's coming. And so she would send us these screenshots through the correspondence, through text messages, and emails, and that's how she provided that.
And that's how you recall these these documents in particular. That's why you're familiar with them. Is that correct?
Correct.
All right. I'll go ahead and, she didn't show, so I'll go ahead and give it to you.
Thank you, Your Honor.
And I'll grant your motion. And, I'll go ahead and sign that, send it today. We'll send her the notification that she has 24 hours basically to post the bond to appeal. All right,
Thank you, Your Honor. We appreciate your
else?
time.
Certainly.
Okay.
Have a great day. Enjoy.
Have a great day. Thank you
Bye.
again. Okay.